Utah and Wyoming team up to sue the BLM for skipping a step in the process before they imposed a new rule that significantly impacts the management and restricts your use of millions of acres of federal land. Hello, I'm Richard Pyatt, and this is Legally Speaking. The BLM rule strictly restricts access in the interest of conservation, the agency says. But Utah and Wyoming are fighting back, saying the new rule was put in place illegally. The states are saying BLM didn't comply with the National Environmental Policy Act, NEPA, which requires a study of environmental effects of new rules on federal land. The Utah Attorney General's office is on top of this lawsuit, saying the BLM exceeded its authority and is limiting access to 245 million acres nationwide of federal public land, including 22.8 million acres here in Utah. We're speaking with Jason DeForest, an Assistant Attorney General in our office, who's on top of this lawsuit. Thanks for joining us today, Jason.
Of course. Yeah, glad to be here.
Where's the land in question in Utah?
Well, the interesting thing about this land is that, about this rule, is that it has the potential to affect all of the BLM land in the state of Utah. It does limit its reach some by suggesting that existing rights will not be affected, but existing rights change. So while it may be the case now, this rule could potentially affect all land within the state, all BLM managed land within the state of Utah going forward.
And what are the main uses of the land that are in question as far as the lawsuit concerned, or in general?
Yeah, so the land it's managed under BLM's multiple use and sustained yield mandate as required by what's known as the Federal Land Policy and Management Act, or FLPMA, which is the BLM's governing statute. And that multiple use and sustained yield mandate has been in place for decades. And since its inception, the FLPMA uses have included things like grazing, mining, timber harvest, and the like. In fact, there are principal uses outlined in FLPMA that include those things: grazing, fish and wildlife development, and things like that. So that is what is happening now. This rule adds conservation to the mix and puts it on par with these other congressionally identified uses. This is problematic because conservation was not identified by FLPMA, one, and it changes that multiple use and sustained yield mandate without going through a congressional process.
How would the new BLM rule affect those who are currently utilizing the lands?
Yeah, so one of the big changes to the rule that's not getting much attention is the issuance or potential issuance of mitigation and restoration leases under the rule. They've not yet been put in place, but the rule allows for those leases to be issued to non-governmental organizations, individuals, or other entities. Initially, it didn't allow for the state to hold those leases. Now, a couple of agencies, the Division of Wildlife Resources and the conservation districts, can hold them as well. But the problem is in issuing leases to non-governmental organizations, the leases could preclude other uses that are different from the purpose of the lease, or opposite the purpose of the lease. So if there is a mitigation lease in place and habitat management is not conducive to the purpose of that lease, well, the DWR could then be precluded from going on to that and conducting habitat management, say, for mule deer or for sage grouse or for other wildlife within the state. So, and similarly, if a mitigation lease is in place, an organization like the Grazing Improvement Program throughout the state could be precluded from continuing to do range improvements, which would affect the watershed or could affect other elements of the landscape out there that the state is currently working to protect, and they may not have that ability if a lease is issued.
Okay, so are these proposed leases different than the existing leases?
They are, in that this is the first time that under FLPMA, they're allowed to issue these leases to these non-governmental organizations for the express purpose of mitigation. And I think an issue with that is, and of course we don't yet know what this will look like in implementation, but a major issue is we don't know what qualifications these non-governmental organizations will have, if any. And I think it's fair to say that it's completely uncertain whether they would have the same level of expertise as, say, Utah's Watershed Restoration Initiative, which has been doing this for decades. So to hand the reins over to an organization that doesn't have that kind of expertise, and maybe more importantly, to remove the potential for WRI, the Watershed Restoration Initiative, to conduct that work is problematic and needed to be at least considered in their review of this.
One of the tenets of a lawsuit is that it didn't comply with NEPA when it issued the rule. What is involved for BLM? What would have been involved for BLM to comply with NEPA?
Sure, yeah. NEPA requires that the BLM take a hard look at an environmental effect of a major federal action. So if there's a major federal action on the ground and has the potential for environmental effects, they are required to take a hard look. And in this instance, given what I've spoken about these agencies that have been working on the ground, taking that ability away from them to manage as they have, to actively manage the landscape, could result in additional wildfire risk. It could result in changes to the watershed. It has a significant amount of ramification for an agency working to protect the environment. And so at minimum, the BLM needed to come in and say, how will this affect if we issue a lease, a mitigation lease or a restoration lease to a non-governmental organization, and that restoration lease doesn't allow for the active management the state is conducting, how will that affect the environment? How will it affect the larger scale picture, what the state has been working on for decades?
Does this rule have deeper implications too?
I think so. I mean, I think that it has implications into the future about how the land will or could be managed. Another piece to this that we haven't yet discussed is the ability of local BLM managers to define intact landscapes and to put in place what's known as areas of critical environmental concern, in part, I think, based on what they've identified as intact landscapes. And that has the potential to significantly change management on the ground, even in the absence of a mitigation or restoration lease. If a local manager identifies an intact landscape and then designates an ACEC on that basis without going through the proper public processes, again, without going through NEPA and without coordinating with the state with regard to ongoing management, it could lock up significant amounts of land and preclude the state from continuing in that management.
So how are Utah and Wyoming working together on this lawsuit?
Wyoming has similar concerns as Utah does, especially given that the BLM did not conduct NEPA on this rule. They're a bit different from Utah in that they have different management structures and they different management implications. And I won't speak for them, but one of their major issues was sage grouse. And they've spent millions of dollars and decades conserving sage grouse. They have the largest population in the world of sage grouse. They've taken that responsibility on very heavily, and they've invested a ton of money and resources in the protection of sage grouse. And this rule doesn't allow for cooperation and coordination from other entities that are allowed to hold these leases. So if you imagine a non-governmental organization holding a lease right in the heart of sage grouse territory, there's no requirement for them to coordinate with what's already in place by the state of Wyoming to protect those birds. And so at minimum, that required some evaluation from BLM to consider those potential environmental effects.
How does this lawsuit fit in with the other lawsuits that Utah is involved in against the federal government when it comes to land use and jurisdiction and those kinds of issues?
Yeah, the state's desire is to be an equal partner in the management of these lands, right? If you look at wildlife, the state very clearly has jurisdiction over wildlife, and wildlife uses the public lands and will continue to use the public lands. And so we very much need to be a partner in a process like this that changes management on the public lands. And it's part of a broader goal to ensure that we are actively engaged with the federal government and an equal cooperating partner in anything that will affect our interests on these public lands.
Okay. So what's the next step? Are we going to be in court anytime soon on this one?
No, it'll take some time to move through some litigation from this one. We just filed the complaint, so we're at the very beginning stages of this process. Going forward, we want to ensure, in this case and in all others, that BLM considers these potential environmental effects for a state like Utah and Wyoming that has so much public land and is so involved and interested in managing those public lands.
Well, it sounds like a very complicated lawsuit, though. Even still, so you got a lot of work ahead of you. It sounds like.
Yeah, it'll be a busy summer.
All right. Well, thanks for the insight, Jason DeForest. Thank you very much for joining us on Legally Speaking.
Thank you.
And thank you for listening to Legally Speaking. I'm Richard Pyatt. We'll talk to you next time.